Practical steps for compliance with Maryland's new sick leave law. Before we get started, I would like to go over a few items so you know how to participate in today's event. You have joined the presentation listening through your computer speaker system by default. If you would prefer to join over the telephone, just select telephone in the audio section of your control panel and the dial-in information will be displayed. You will have the opportunity to submit text questions to today's presenters by typing your questions into the questions box of the control panel. You may send in your questions at any time and we will address them at the end of the presentation. I would now like to introduce today's presenter, Peter Guattari, partner at Whiteford, Taylor & Preston. Welcome, Peter.
Thank you. Thank you. Welcome to everybody who's joined the webinar on the Maryland Paid Sick and Safe Leave Law, which is otherwise known as the Healthy Working Families Act. My name is Peter Guattari. I'm an attorney at Whiteford, Taylor & Preston, and I practice in labor and employment law and have been here for 31 years. Today we're going to discuss the impact of Maryland's new sick leave law and some practical considerations about applying this law with your current policies and how to come into compliance. I think everybody should know that this law is currently effective. It went into effect on February 11th, and if you are not presently in compliance, then you should be getting into compliance as quickly as possible. There is some guidance that is available on the Maryland Department of Labor Licensing and Regulation worksite. You can simply go to the DLLR website and click under the link, I believe it's on the right-hand side, for Maryland Healthy Working Families Act, and you will find not only a series of FAQs addressed to the law and questions about the law. You will find a sample policy, actually two sample policies, and you will also find a sample notice for posting. And that notice, if you do not have a notice up already, which you should, that is the notice that you can use to advise employees of their rights under the Act. So I encourage you, you don't have, excuse me, do it now, but after the webinar is over, if you haven't had a chance to look at that DLLR website, do so and look at their sample policies. They're actually quite well written and can be used to incorporate into your current policies to create an effective and compliant policy on the Healthy Working Families Act. So how did we get here? Well, in Maryland, for the past few years, you've had only a few laws which have imposed leave requirements. You had the FMLA, which applies really only to any organization with 50 more employees. You've had a Maryland parental leave law, which is, in a sense, supplement, providing 6 weeks of leave following birth or adoption for employers of 15 to 49 employees. And then you had sort of the piece that started it all, Montgomery County implementing its own paid sick leave ordinance, on which the current law is somewhat modeled, but not entirely. And subsequent to the Montgomery County law, there was, I believe, Prince George's County tried to pass a law but did not do so. Then the legislature passed this law, and it was vetoed by the governor in 2016, and then it became up again for the next session and became actually 2017, I'm sorry, and then in 2018, the veto was overridden and the law went into effect as of February 11th. There were some attempts to delay implementation to July. I've had people ask me questions about that still. Those efforts to extend the law to July did not pass, and the law became effective February 11th. However, the Department of Labor Licensing and Regulation has said is that at least up until July 1, its enforcement efforts will be more educational than compliance-oriented in the sense of imposing fines or sanctions. So who is covered under this law? Well, essentially every employer. The distinction in this law is who gets paid leave and who doesn't get paid leave. And the line is drawn, as is typical with many other statutes, at 15 or more employees. So any employer with 15 or more employees is going to provide paid leave under this statute, and anyone with 14 or fewer employees is going to provide unpaid leave. Now, how do we count employees? Well, the law provides some guidance on counting employees in addition to the FAQs, looking at the average monthly number of employees during the immediately preceding calendar year. So that is determining how many employees you have each month and then coming up with an average number. And if it's a 15 or above, then it's paid leave, 14 or below, unpaid leave. Now, this counting includes all employees, seasonal, temporary, people under 18 who may not be eligible for leave. But it only includes Maryland employees. So if you have 14 employees in state and 25 employees out of state, those 25 out of state employees wouldn't be counted. Now, with respect to those out of state employees, keep in mind that even though out of state employees wouldn't be eligible for the benefits, if you have an employee in Maryland whose primary work site is Maryland, and they do some work out of state, then not only would they count as a Maryland employee for purposes of this law, but they also would be entitled to benefits based on their total hours, including work out of state. Who's excluded from employee? Independent contractors are excluded, and that means true independent contractors, which is, particularly in this state, a question of open debate as to who is an independent contractor. If any of you have litigated this issue with unemployment, you'll find that they take a very strict line as to who is and who is not an independent contractor. Also excluded from the definition of employee are employees of temporary staffing agencies who provide services to another person, where the TSA, that is the temporary staffing agency, does not have day-to-day control over work assignments and supervision. So that would be essentially someone where the TSA brings that person, basically places that person with another employer, but really doesn't control any of its work authority. It also does not uncover, that is the term employee, persons directly employed by a TSA to provide part-time or temporary services to another person. What's left unanswered here, and what is an open question, is whether long-term temps at a work site of an employer would be covered as employees of that particular employer. That is to say, somebody who's placed by a temporary staffing agency, paid by a temporary staffing agency, but has been working on your work site for an extended period of time, perhaps 3 months or more. Those individuals may very well be employees covered under this law. That's an open question. We don't know what the answer to it is yet. In addition to exclusions from employees, there are exclusions from leave accruals. And it's important to keep that in mind because people who are excluded from the definition of employees wouldn't even raise an issue as to whether they're covered, but exclusions from leave accrual are essentially you're saying that's a covered employee, but these particular employees don't get leave. The most relevant one in your circumstances would be somebody who works regularly 12 hours a week or fewer. What does regularly mean? Well, the ever helpful FAQ says that regularly means normal and customary, which begs the question of what normal and customary means. I have dealt with this issue on a few occasions, and my advice to the clients is generally if you have somebody who's working between 10, 11 hours a week or fewer, that's obviously regularly. If they spike and hit 14, they're probably not entitled to coverage, and that's not going to invalidate them being regularly employed as long as those spikes don't happen all that often. That is, a few hours above 12 isn't going to cause you problems. And there's another provision of the law I'll get to which addresses that. But really you're looking at people who, if you were to say, how often do they work? You can say, oh, they work about 10 hours a week or so on a regular basis. you know who they are. Those are people who are not going to accrue leave under this law. There are also exemptions from accrual for employees in the construction industry who are covered by a collective bargaining agreement. And then perhaps also pertinent here are employees in the health or human services industries who are called to work on an as-needed basis. Now, those would be PRN employees who might be called in to fill in spots for nursing or other types of care where regular full-time employees aren't available. And a number of associations provide a list of or maintain a list of PRN employees who can be called for those emergency staffing needs. Now, note that it's got three requirements: that the individual is called to work on an as-needed basis, where the employee can accept or reject the offered shift, is not guaranteed to be called on to work, and is not employed by a temporary staffing agency. All of those provisions have to be applicable. Now, a question has come up from at least one client is, well, what does it mean to accept or reject the offered shift if we have a rule that perhaps requires them to accept at least one shift within a certain number of, within a certain period, and if they reject that shift, then they will be taken off the list. If that raises an interesting question, because it's one that's not clearly answered. They clearly can accept or reject any offered shift, but if they have previously rejected two shifts and then they come upon a third offer, they may not be in a position to reject that without potentially being taken off the list. So does that mean that that employee is excluded from leave accrual? Difficult question to answer, depend on the circumstances. They may not be eligible for leave anyway if they're working so few hours that they're not being covered by the act. That is, they work less than 12 hours a week, or they meet one of the other exceptions. Now, how much leave do we have to provide? Well, the law requires at least 1 hour of leave for every 30 hours worked, up to a maximum of 40 hours earned per year, and a cap of 64 hours accrued at any given time. Employees who have carried over leave from a prior year may use up to 64 hours in a year. Now, there is another provision of the law which deals with how this leave is awarded, and I will come back to this issue here as to how much leave in two slides, actually, because it's actually a very interesting question, and I want to make sure everybody sees how these accrual and use rules work. Now, there are certain special accrual rules that provide that employers are not required to allow an employee to accrue leave during a 2-week pay period in which the employee worked fewer than 24 hours. A 1-week pay period if the employee worked fewer than a combined total of 24 hours in the current and immediately preceding pay period, or pay periods where the employee is paid 2 times per month, regardless of the number of weeks in a pay period, and the employee works fewer than 26 hours. My understanding of these special accrual rules is that they're intended to deal with the issue of employees who work fewer than 12 hours but might be bumped up in some way to more than 12 hours in any particular week. These are intended to sort of deal with that threshold question. It's possible that these could affect full-time employees or employees who work regularly more than 30 hours a week if for some reason their hours go down. But it's more likely going to affect employees who are at that threshold of 12 hours, and I believe they were included in essence to specifically address those concerns where you have that increase in pay or increase in hours worked. Now, awarding and tracking leave, and this is where I want to come back to the accrual rules. The Act gives employers 2 options. On option 1, an employer can award the employee the full amount of leave that employee would earn over the course of the year. That is, you would give them the 40-hour maximum for employees who are regularly scheduled to work a full-time schedule. Generally, it's anyway. If you figure out the number of hours, it's generally above 24 and above hours per week would result in 40 hours, because 40 hours per week over a full year period would come up to about 67 hours. So anyone who's regularly earning more than 24 hours a week is going to be earning the 40-hour maximum over the course of the year. The second option is to award leave as it is accrued by employees. Now, you may say, gee, I'd rather award it as it's accrued because it's easy, and that way I can simply track the hours worked, and for every 30 hours I give 1 hour of leave up to the maximum. But the Act provides employers with an incentive to choose the first option by providing that employers who award the full amount at the start of each year do not have to allow employees to carry over unused leave from year to year. Now, note that if the employee is entitled to carry over up to 40 hours from year to year, you run into an interesting mathematical problem. And that is, let's assume an employee carries over 40 hours from year 1 into year 2. In year 2, they can accrue an additional 24 hours up to a cap of 64. And then that employee could take 20 hours, their leave total balance down to 44 hours, but at that point, they can then accrue an additional 16 more hours up to the cap of 40 hours earned in any year. So now they're at 60 total hours, and they could use an additional 20 hours during that year and be left with a balance of 40, which they could then carry over to the next year. And that's a pretty clear reading of how these accrual and carryover rules would work under the statute. And employers would need to be very alert to that possibility, because employee can come in, carry over that 40, then earn additional 24 up to the cap. But then if they use anything, they still have room to accrue more hours up to the total accrual limit of 40 in any given year. So you have to be mindful of that. And many clients have taken the option of simply awarding all of the leave up front on an annual basis and leaving it at that. And because they feel that's a cleaner option to keep track of the total number of safe and sick leave hours the person has under the law. Now keep in mind, you can also determine when the year begins and ends. So you can identify the year as being January 1 to December 31st, March 31st to March 30th, or from June 1 or July 1 to June 30th, however it works. The FAQs specifically recommend that any policy front-loading sick leave be in writing. And keep in mind that if not for front-loading leave by giving it up front at the beginning of each year, that the caps and accrual requirements are going to apply, and you should be very cognizant of that. Now, how can we use leave? Well, obviously, for the employee's own illness or medical condition for which they're need to take leave, for obtaining preventative medical care for the employee or family member. And keep in mind that family member is extremely broadly defined in this statute and includes persons who you might otherwise not include in the definition. And for example, it can include obviously a biological child, an adopted child, a foster child, or a stepchild, a child for whom the employee has legal or physical custody or guardianship, a child for whom the employee stands in local parentis, biological parents, adoptive parents, foster parents, step-parents, or the employee or the employee's spouse, or legal guardian of the employee, an individual who acted as a parent or stood in local parentis to the employee or to the employee's spouse when the employee or the employee's spouse was a minor, spouse of the employee, biological grandparent, adopted grandparent, foster grandparent, step grandparent, and biological grandchild, adopted grandchild, and so on. And it's a very, very broad definition. So don't limit yourself to the definition of a nuclear family. This is more of a nuclear bomb group of families that you have to understand are covered within the meaning of family in this law. And so leave can be permitted to care for a family member with a mental, physical condition, illness, or injury. Law also permits use for maternity or paternity leave, or obtaining treatment or services in connection with domestic violence, sexual assault, or stalking. And that includes specifically obtaining legal services in connection with any of those instances, domestic violence, sexual assault, or stalking. So what are the mechanics of requesting and using leave? Employers may require employees to provide 7 days notice prior to the use of the leave if the need for leave is foreseeable. If the need for leave is not foreseeable, then the employee is required to give notice as soon as practical, which in shorthand means generally whenever the employee gives you the notice, unless it's a very extreme case and you can demonstrate somehow that they knew sooner. An employee is also required to comply with an employer's general notice and procedural requirements for requesting and reporting leave, provided those requirements do not operate to interfere with using the leave provided by the Act. So if you have a policy which is so restrictive that it requires notice at a minimum within 2 days, that may not be as soon as practical, and therefore that may be a policy you can't enforce in a specific case. Note that an employer may deny a request for leave if the employee fails to follow the appropriate notice procedures and the absence would cause a disruption to the employer. So you say, aha, a disruption. I would suggest very carefully here and conservatively that you can expect that disruption to the employer will be read very narrowly by the Department of Labor. It is expected it would be strictly construed and there would not be a tremendous amount of leeway. Of course, this is always on a case-by-case basis, and we're going to have to see how the law specifically develops here to define the scope of what is a disruption to the employer. Keep in mind that an employee may only use that leave which is accrued or awarded. There is no requirement that you advance leave to any employee under the rules. So, other specific requirements the law imposes, the employer cannot require an employee who is using a leave provided by the Act to find another employee to fill his or her shift. An employer and employee can agree by mutual consent that the employee will work additional hours or trade shifts with a coworker during a pay period or the following pay period in order to make up work hours that might be missed. But in that case, that particular use of time is not going to deplete the paid leave balance because the employee has actually covered it by working additional hours or working a different shift. But note that specifically requires mutual consent between the employee and the employer, and coercive efforts or coerced consent isn't going to be adequate to meet the requirements of the law. Now, there are special rules for tipped employees in restaurants, and there are special rules for services to developmentally disabled or mentally ill individuals who are providing those services under state law and licensed to do so under state law. I won't go into those in detail, but I mention them just for the sake of completeness. Now, one of the more cumbersome aspects of this law is the requirement of tracking it. And all leave that's accrued and used under this statute must be tracked. And employees must be advised of it in their paychecks as to what their accrual balance is. Under the statute, employees can take leave in the smallest increment that the employer's payroll system uses to track absences. That might be as small as a quarter hour, but the maximum is 4 hours. Don't assume that you're going to simply use 4 hours because, heck, it's this type of leave. That may be improper. But where you have, generally you track leave in increments of, say, a quarter hour to a half an hour or so, those might be appropriate increments in which leave is recorded and tracked under this statute. There is a waiting period for the use of the leave. An employer does not have to permit an employee to begin using leave for the first 106 days of employment. That is what I like to call the Ocean City rule, because I believe that is why it is in there. If you look at the number of days between Memorial Day and the Labor Day. So an employee may be accruing leave during that period, or may be awarded leave at the beginning of employment, but does not get to use it until those 106 days. Now, an employer can allow an employee to use that leave in advance, but there are specific requirements as to what an employer must do, particularly if the employee were to leave shortly after using that leave and recouping the use of that leave, and what must be in writing. So if that's something that you want to do in your policy, or your policy permits use of leave prior to being accrued, keep that particular caveat in mind. There are a lot of provisions of this statute which, if you want to do something in terms of using a leave or notice of leave, that there has to be a specific documentation of that in order to show that the leave was used and that the employee agreed to the terms of use. Now, leave generally under this law is not required to be paid out at termination. However, if the employee returns within 37 weeks, they would get their accrued leave balance back unless you paid it out when they left. Now, their employer, I spoke of the notice and record keeping obligations. An employee must be provided with written notice of their accrued paid leave balance each payday. This can be done electronically. An employer could use a portal to do it. It can be done on their paychecks. Many paychecks already identify a specific leave balance on the paychecks, and it would simply be a matter of modifying that information in order to identify the particular leave balance and that it relates to accrued sick and safe leave under this statute. As I mentioned at the very beginning, an employer has to provide notice of employees of their rights under the Act, and there is a poster that has been created by the Department of Labor Licensing and Regulation that is available for you to post, and if you don't have it posted now. Employers are also required to keep records for 3 years regarding the amount of leave that's accrued by each employee, as well as the amount of leave the employee has used. And if you consult the FAQs, which I mentioned previously, you will find that they specifically say that if a complaint is filed, an employer must be able to demonstrate to a commissioner how many hours the employee worked, how much sick and safe leave act was accrued, and how much of that leave was used by the employee. So you need to keep very specific records about this particular leave and the extent to which it was accrued and used by the employee. And failure to do so can result in monetary penalties and fines. And that brings us to the next question, which is we already have paid leave policies. We already provide more than what the law requires. What does that mean for us, and how do we integrate it? Well, the law says that the Act may not be construed to require an employer to modify an existing paid leave policy if the policy permits an employee to accrue and use leave under the terms and conditions that are at least equivalent to those described in the Act. Or the employer's existing policy does not reduce employee compensation for an absence due to sick or safe leave. Now, I offer several caveats to that. And that is, at least equivalent means, in my mind, the same as. And the statute specifically says that the employee must be able to access and accrue the leave. Well, what does that mean? Does that mean that all of the rights that apply to sick and safe leave in the statute must be incorporated with respect to your existing policies, at least with respect to any leave that's being used for sick and safe leave purposes? I would say the answer to that is yes, because that's a question of access. You are accessing that leave on the same basis if you're not being penalized for the use of that particular leave, and that it's being allowed to be used for all of the purposes that the law provides. And that has created some problems that I have encountered on a practical level on how it's going to be applied. And I'll come to those in just a minute. Specifically, what if I think my employers are abusing the leave requirement? Well, the Act provides that it may not be construed to prohibit an employer from adopting and enforcing a policy that prohibits the improper use of leave, including a policy prohibiting a pattern of abuse of leave. But the law also contains a provision stating that an employer may require a verification that the leave was used for a proper purpose if the leave was used for more than 2 consecutive scheduled shifts. So you can't request, that clearly suggests you can't request verification if the absence is for only 1 shift. Okay? Well, what if you have a pattern of individual absences on Friday? And it's week to week, or every other week, that they're out on Friday, which coincidentally might be a payday. And the employee is giving you an explanation, I was sick. I would suggest that in that circumstance, that applying a policy prohibiting a pattern of improper use of leave is going to be very difficult to enforce, because each one of those individual instances of leave is protected leave. And taking action against the employee as a result could be very difficult. You would probably need evidence to show that the reason given by the employee for that absence was false. And I think of a recent case I just saw addressing a similar issue under the Family Medical Leave Act of a guy who was out golfing on a day that he was supposedly incapacitated due to an illness. And in fact, it was posted on Facebook and somebody saw it and reported him to the employer. So that's probably going to be the circumstance that you're going to be limited to, at least in those factual scenarios. Because the law has anti-retaliation provisions, that an employer may not terminate an employee or otherwise retaliate against an employee due to the employee's exercise of rights under the Act. And if we had this pattern that wasn't a 2-day-in-a-row absence, at which point leave, there might be a requirement to give verification at that point, then it's going to be very difficult to police these absences. Also note that an Act expressly provides that an employer may not apply an attendance policy in such a manner that an employee's use of leave under the Act is treated as an absence that counts towards the potential imposition of discipline. So a lot of employers have absence control policies that give points for absences. What this specifically means is that you can't count any leave taken under this statute toward that limit under your absence control program. So what has that meant practically in terms of putting these policies together? You have a PTO policy. You want to say our PTO policy is generous. It provides more leave. Well, maybe that policy provides on an accrual basis and you don't want to use the accrual basis for sick leave. Maybe you want to separate out PTO for all other absences other than those covered under the Maryland Sick and Safe Leave. And I've had clients who have done that. I've had clients who use the combination of the two. But it's really a question of making sure that it's something that you can track. And being able to integrate the policies in a way so that for leave that is taken for purposes under the Act, all of the rights accorded that leave apply, including the non-retaliation, the notice requirements, the counting against, any attendance policy, the requirements for verification, etc. Because once you hit that limit of leave, let's assume it's 40 if you're using an award per calendar year. Once you hit that limit, any leave above that can be treated as outside of the Maryland law and therefore could be counted against an attendance policy unless otherwise prohibited under some other law. Okay? So that's why it's not just so important to track this leave on a per employee basis, but also to in many cases for employers who have decided, I'm going to separate out these policies because it makes it easier for me to track. And that may mean taking 40 hours out of the mix for PTO and or some other number of it and creating two separate policies that work in coordination in some way. Another thing to note about the potential penalty for failing to give notice is that it's really weak. It's really weak. It's not that you can suspend or terminate or discipline the person for failing to give you the verification required. It's actually that if they fail to give the verification as requested, an employer may deny a subsequent request for leave that is for the same reason of the other leave. Again, that's going to be hard to implement because one suspects it probably will be for a different reason, and therefore you'd be in a position to have to give that particular leave. So how is this whole law enforced? Well, the enforcement mechanism is through the Commissioner of Labor. And there's an administrative complaint form that's actually on the DLR website that you can take a look at. And that would be the process for starting it. And once the employee fills out that administrative complaint and files it with the commissioner is going to investigate the complaint. They're also going to attempt to mediate that complaint within a 90-day period. And if mediation of that complaint is not successful, and the commissioner finds that a violation has occurred, the commissioner can issue an order directing payment of the value of any unused leave, as well as any actual economic damages that may have been suffered. So that's the leave, plus what other economics they can show they might have lost health care, lost, coverage of a prescription, maybe, mileage or other reimbursement type things that the employee might come up with. I mean, it's sky's the limit in terms of imagination there. And then a civil penalty of $1,000. Now, where does the employee step into this process? Well, if the employer does not comply with the order, either the Attorney General or the affected employee may seek enforcement of the order in court. And if the employee prevails, the employee may be awarded attorney's fees and punitive damages under the law. So that gives you an incentive to comply with the order of the Attorney General, of the Commissioner, unless there is some specific reason why you would not want to comply with it, such as that the order is flawed, and you could fairly well defend it, because the employee could get not just punitive damages, but attorney's fees. And as anyone who knows who's been involved in litigation involving attorney's fees often become the tail that wags the dog in terms of moving resolution of a claim. Because at that point, people are interested, or the lawyer is interested in their attorney's fees much more so than probably what are nominal damages under the statute. So that's basically it with respect to the requirements of the Maryland Healthy Working Families Act. I'm happy to take any questions that you have, and I'm sure there are questions that apply here. I have one question here. If an employee requests a leave and it's denied, then they call out. Are there any ramifications the employer can give the employee? Well, that's a good question. Very interesting question of how the law would operate here. And my read of it would be that, remember, you can only deny the leave if they fail to give proper notice and it would cause a disruption to the employer. So your success in denying the leave and being able to take disciplinary action against that employee are probably going to be dependent on the strength of your defense that the leave caused a disruption, whatever that might be. Let's say an employee knew they had, let's say they had a child who was scheduled for surgery, outpatient surgery. They knew it for 3 months. They didn't tell you until 2 days before. That was the only employee scheduled for that particular shift over a weekend in which you didn't know that anybody else could be available. And that employee tells you 2 days beforehand, I can't come into work, but they're a key employee or a critical employee on that shift that day. Then maybe you have and the employer can't get anybody else to fill in and they try. At that point, they may have a valid case to say, we can't let you go because doing so would cause a disruption. We can't get anyone to cover. You knew about this 3 months ago. You didn't tell us the 2 days before, and you knew the schedule, but you didn't say anything, and now we're locked in. That's a potential scenario. Is it a disruption? I think you're going to find that it becomes a litigation issue. You may wish to take a hard stance or not, depending on the factual circumstances, and you may be in a position to discipline that employee on the basis that they called out, but only if you can legitimately show that you had a right to deny that employee the leave. Otherwise, I think you run the risk of violation. Another question says, if our policy is that an employee lose their holiday pay if they call out the shift before or after the holiday, can this still be the case if the employee is calling out under one of the covered reasons for leave? Well, I'm not quite sure how your policy works with respect to holiday pay and employees who are out on sick leave under the ordinary course. And that would be the first thing that I would look to in terms of how the policy works. In some instances, if an employee is out sick on a particular holiday, then they might be paid sick leave for that day, but not holiday pay. I'm not also sure if the holiday pay in this case is separate, is like a premium pay or just a paid day. I'm assuming that in this case, it would be a day off for the employee and they have holiday pay. The retaliation provision in the statute might possibly cover this if the employee had a legitimate reason for calling out and there was no basis for denying them that particular leave. Then they may say, you cannot penalize me and cause me to lose the holiday pay if my leave is properly taken under the statute. The best I can tell you is that seems to be an open question, and I think it would depend a lot on how the particular policy operates. that's probably not all that satisfactory in this case as an answer, but it's really hard to extrapolate from the law, particularly given the protections that are accorded employees under the statute. It's really hard to extrapolate what they may interpret as retaliation in this case. For instance, it includes discharge, demotion, threatening the employee with discharge or demotion, or, and here's the kicker, any other retaliatory action that results in a change to the terms or conditions of employment that would dissuade a reasonable employee from exercising its rights under the subtitle. And then there's a provision that says a person may not interfere with the exercise or attempt to exercise under these rights. And could this be interference if you deny the holiday pay? I can't answer that. I think it's a fair question that's out there, and it may be one that necessitates looking at how your policy works, particularly as it works with respect to use of the award of holiday pay and the use of sick leave. Okay, and another question. Let me see this. In healthcare, one can be working short due to a call-out. Another call-out may create a major problem. A third would create a true crisis. How would an employee weigh the different call-outs for the same reason but affecting the business differently in terms of denying the leave? Again, that's going to depend on when I would think that you would prioritize it based on when the specific request came in. And if the third person calls in and they have a situation where it would have been leave that was known, foreseeable, then that may be a basis to deny the leave. Perhaps that third person does not. The second person who's called in, the third person may not be foreseeable, the second person was. You might need to go back and look at that second person again and say, we've had a subsequent call out and I'm afraid we can't grant you the leave at this point in time. That may be hard to do. It's hard to say where you're going to fit in that spectrum, but I could very easily see it creating a real problem with respect to if one person calls out, that may not be a disruption. If a second person calls out, that may be. A third person may call in that creates a true disruption, but they may not have foreseeable leave requests, so you may be put into a pickle there, which may mean that at that point you might have a potential scenario where the application of your policy as to call-outs might come into play. If you remember, I discussed that earlier about an employer's policy on using leave and how it can be imposed, that you may need to rethink that policy and this potential and how it occurs as to how it might be applied here. If somebody calls in at the last minute and there's a third call out on a shift and all of a sudden you're shorthanded for what is providing medical care perhaps for residents. Again, it's not a clean answer, but it's one that probably is going to require some thought as to how the policies are going to interact and apply in this case to determine who gets and who does not get leave. Maybe you have something that says that you give a provisional grant to the second person provided there are no further call-outs because that person may have known of leave but didn't tell you. That might be another way of approaching this problem. Again, it's going to be heavily case dependent and very fact specific as to what the circumstances are for the request, what the requester knew, and what the employer's particular needs are with respect to staffing at any given point in time. All right, any further questions? All right. Well, I hope that I've answered a lot of questions regarding this law. I apologize if there are certain things which are left vague and unclear. My purpose isn't to confuse and confound you and leave you saying, what the heck was that all about? But to encourage you to think a little bit more about the requirements of the law and your policies and how you might draft your policies in a way to deal with some of these vague questions and allow yourself some room to be able to address these problems. So again, thank you, and I wish everybody a good day.
Thank you, Peter, and thank you everyone for attending today's webinar, Practical Steps for Compliance with Maryland's New Sick Leave Law. On behalf of Whiteford, Taylor, and Preston, thank you for joining us today and have a great rest of your day.